Welcome to another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences. I am Dr. Bill Kanasky. My guest today, repeat guest, he was on very early in the lifespan of this podcast, and we really deeply appreciate him. Trial attorney and good friend, John Hall. John, what's shaking up there in Georgia?
Hey, Bill, a lot of humidity around and trials stacking up, as you know, and so it's a lot of fun right now. Good
Yeah,
times.
speaking of humidity, I've got
Oh,
my copy right here. Gnats, Humidity, and Murder, a book that you authored, and you were so kind to give me a free and autographed copy. And it's sitting right here on my desk. So the trial that I am currently consulting on, that's actually going about 3 months. When that's over, this is my top priority right here. So I guess the first and natural question is, well, number one, congratulations on the publication of this book. The question is, how does a busy trial attorney possibly find the time to author a book? How do you do it?
it was over a 3-4 year period, and it actually turned into 3 books. That's the first one that was out.
Oh, great.
The continuing series, and I would have an idea and think that doesn't fit here. Let me put this over here. So I'm working on the finishing up the other two, but mostly, I'm in hotels a lot. So
Yeah.
instead of Shark Tank, 3 hours worth, I watch what hour Shark Tank and then do some typing. Airports, and then just sitting around. For me, writing's an escape. I just sit down and kind of do it from a chain of consciousness, and so it goes quickly and it gets me away from other things for that time period.
That's awesome. As you know, I'm a prolific writer. I keep it more on the scientific end and the nonfiction. But I think you're right. Being able to write, turn your email off, just focus on your thoughts and be able to type away. That's I really love it. And like you said, I guess we can thank airports, airlines, and Hilton and Marriott for all that time on the road to
Exactly.
get those things done. That's excellent. Well, again, congratulations on the book. I'm really looking forward to getting into it. Thank you for coming on the show today. The reason we saw each other in Orlando a couple weeks ago is fantastic to see you. And you gave a great talk to the folks down there at the seminar. And one thing that we talked about was the amount of trials going on. And so we're halfway through 2024. The amount of trials going on is beyond insanity.
Yeah.
And I think it's important to because many of us were not in trial mode for a couple of years there, right? With COVID, and then there's this backlog. And I think it's important to talk about trial skills, trial tactics, the mindset of trial. Because now that we're jumping back into trial, and I'm on several trial teams, have been and currently am, and I kind of see, I see various things from trial teams. Um, and a couple things I want to talk to you about. Number one is the stress level of trial is I'm not sure I can compare it to much else. It's extraordinarily stressful, as you know. You have your team around you. There's physical stress on the body. There's emotional stress. There's mental stress. As you and your team approach trial, I'll dive into those three topics. What's your overall approach to managing and dealing with the chaos and stress that comes with particularly the week before the trial as you're pushing forward motions eliminate lining witnesses up? There is a lot to do, and it's just a big ball of stress, isn't it?
It is actually once you get to this trial, from my perspective, the stress kind of goes away. It's you're getting an opportunity and you're focused clearly on one thing. That week or two before, I think one of the biggest challenges is the rest of the world doesn't go away that week or two before, and you've
Yeah.
got to learn to balance it. And the key is team and organization. We do pretty basic. We have something we call an order of proof, which really is roadmap of the trial, both the pre-workup on the trial itself, and dealing with issues. And we come out pretty early with that. We give people very specific assignments, give them with deadlines. I find a lot of people, one of the problems for lawyers and I figured this out when I was at the U.S. Attorney's Office as an intern doing some regulation writing. I found I could end up going for years on one project just over and over and over trying to get it perfect.
Yeah,
And you're never going to get it perfect.
true.
And for lawyers, it's understanding that you go do it, you do the absolute best job you get it done, and then you move on to the next thing. You having a finish to it. Now that doesn't mean, when you get some time and you go back and you look at it again, you don't make revisions and changes, but it does mean that between that time, you aren't fixating on that one thing and therefore abandoning or not doing those others. And by having a clear list with hard deadline and expectation of finishing during those period of time, I think you're better able to manage the stress of having those things done. And that's our key, is just that organization and that understanding that the project, when it's finished, it's finished. We'll come back to it, but move to the next one and keep that going.
Yeah. So when you assemble your trial team and the people working around you, how do you find the best way to communicate with them, particularly once trial starts? Because there's so many moving parts, and you've got the trial, you got the things going on in the evening and early morning. How do you keep your team on the same page and not get off track?
Yeah, there's different styles to do that. We come up with a war room. I find it counterproductive to get a bunch of people in one room working. I've seen folks that we try cases with will want to come in and everybody be in one room working at the same time. I think that's
Agree.
counterproductive. You ought to have your assignment, and it's part of this organization. We actually, if you come to one of our trial team, I can send you a photo. If you look on the wall, I have these Post-its that's got every day covered, every event, every person assigned, where they are on those things. And so at the end of each day, we'll go look, okay, what did we do today? What do we have to do that we've got to accomplish before in the morning? Here's your assignment. Here's your assignment. Go out and do it. Let's get back together in the morning and we'll review where we are before we go back in to where we're going. But I think you have to have that flexibility, not to turn it into one of the thing that irritates me most about trials and folks, they want to come in and talk about all the stuff that we just did today, from what the judge was doing or what the plaintiff's lawyer. I don't care. My
Yeah.
job is to get my booth in front of the jury. I'm not worried about the tangential things. Let's focus on what our proof is going to be, and let's have it ready to present up that next day. So I think
Yeah.
it's that organizational, and I'll be repetitive on all this. It's that organizational. I have a to-do list. We're going to get to that to-do list. We're going to finish it, and then we're going to move to the next thing so that we're ready to go.
Yeah, the current trial I'm working on, we actually have two different war rooms. We have one with the printers, the copiers, the paralegals, the associates doing their thing, and then the key trial attorneys and me, and where we're bringing witnesses completely separate. Because you're right, the amount of chaos in one room is that it's incredibly distracting, and that like distraction is certainly the last thing that you need. How do you, given the fact, particularly as you're approaching trial, given the fact, what, 96 to 98% of cases settle, how do you keep the team mentally focused? Because on this last trial, I mean, it's like the word settlement comes up like 97 times an hour. How do you, this tunnel vision, get the blinders on, block that out, and not fall into complacency on the assumption of, yeah, that maybe there's a high probability of this case settling, but I can't let that get into my head. I got to work on my opening. I got to work on cross examinations. Do you see what I'm saying there?
Oh, I do, and
Yeah.
we just don't do it. We don't talk
Yeah.
settlement. We're there to get that case ready. If in many of my cases, I may be involved in the settlement negotiation. If I do that, I keep it away from the trial team.
Yeah.
I'm going to step out of the room. I'll do those things, and there's no need for them to be updated on, this is close or not close. I think all of those discussions are a waste of time.
Yeah.
Other than and for some clients, they take over the settlement side during trial, which for me is fine because I'm going to focus on what I do. So I think what you have to do is just to have the understanding. We're not going to talk about, we don't talk about. I don't get anybody in the room and talk about, how Caitlin Clark's doing in the WNBA in the room when we're prepping. This isn't a social hour. It's not a social week. If we all go to lunch and we're not going to be working during lunch, then we can talk about those things. But otherwise, everything's focused on that to-do list. Everything's focused on that organizational chart. Where are you with yours? Which one are you doing now? When are you going to be finished with it? What one are you going to do next? And I think it's just that constant reinforcement to stay focused on those issues. It would bother me, early in my career, it would bother me that cases would settle out from under me. And, I might have a depression of a day or two afterwards.
All that work.
Now I understand my job's just to cut the grass.
Yeah.
I don't decide how high the grass is going to be. I don't decide what else I'm going to cut it at the level I'm told, and that means they're going to settle, then fine. But I've got the grass ready. And so that's what we focus on is just staying on a project management without all of the extraneous stuff that sometimes you get in society.
Yeah. And by the way, Caitlin Clark can hit the three, boy.
Gosh,
She can hit the three. I love her. She can pass too. I'm head over heels in love with Caitlin Clark. I think
yeah.
she's fantastic. That's a different topic, different
Well,
podcast.
it's interesting because I think if you watch Caitlin Clark, what you see is the focus during that period of time, all the side issues going on with her,
Yeah, it's the same
all
thing,
the
right?
endorsements, all those things.
Yeah.
During that period of time, all she's focused on is that game. And
Yeah.
that's what we have to be as a trial team. During that period of time, we're going to be focused on our game.
Yeah, she's just razor sharp, and you're right. So many distractions. And speaking of distractions, I think this is a fantastic question. How do you deal with this? So on some of your bigger matters, um, and I've personally witnessed this, and boy, is it a pain. You may have appellate counsel observing. You may have tower insurance people observing. You may have the defendant's personal counsel observing. And every day at, 5:45 p.m., they're all in your ear giving you feedback or telling you what to do or giving you their impressions of how this trial should be going. And I think that's extraordinarily distracting to the lead trial attorney. I'm very curious on how you deal with that because oftentimes those people are not on the same page and they see things differently. Oftentimes they're emotional or panicky, and it can be a huge distraction. How do you deal with that?
Yeah, I don't mind it. I like to hear what they all think. And in fact, if they don't ask me those questions or tell me what they're thinking, I quickly go get them. But I focus them. It's
Yeah,
not the judge did this or that. It is, what do you think? What's the issue? What do you have a point? And I try to keep it, sort of Joe Friday, just the facts.
just the
You give
facts.
me, and then I tell them, I'm going to do what I think I need to do. Now go do what you do. And I don't let them get involved in the level of what I'm doing. I have them give me information, and then I use that information in the way that's going to be most beneficial to my client. And I believe most of them, you got to be obviously some of this is both political and there's psychological, as reassurance you're giving to people as you're going through the
Yeah,
trial because everybody panics.
yeah,
Everybody on that side is panicking, and my job is to tell them no. It's gone in the way it's supposed to be.
yep.
Nothing's changed. What do you have concern about? Let me go focus on it. And so we just keep driving them in that direction. And I've had the point where I had to tell somebody, stop. You're
Yeah,
not going to come in here and do this.
yeah,
If
no,
that's what you want to do, go somewhere else. But if you have a point, I'll listen to your point and then you move on.
yeah. How do you, another question, which is similar to this, as you know, in the trial process, there's going to be really good days, and boy, are there going to be really bad days. Um, Plaintiffs' counsel's going to have some really, really good days. And how do you and your team deal with the emotions of particularly the days that maybe don't go so well for the defense and stay focused through that because it happens in every trial, doesn't it?
It does. If you don't know that is coming, you can get blown away. And sometimes tangential or sideline observers. In fact, I had a trial one time recently where the first 2 days we were killing it, and oh, this is so great. I can't believe we ever offered any money. What are we doing? This is just, I said, you got to wait. We've done good on their people, but we knew these folks that they put up, we were going to do good, but they've got some good folks and they're coming.
Yeah,
And next day, sure enough, we get one of those folks. Oh God, it's called, it's all terrible. I
it's
said, no,
over.
stay
We're
the
done.
same. Nothing's changed. It's exactly as we anticipated. And I think you got to give those folks that reassurance. And just personally, in the front end, I talk to everybody. It's going to be ups and downs.
Yep.
We're going to have bad days on these issues. And then we go look at the case each day, and I do a sort of an evaluation each day. If I could start that day over, would I start it over and judge the day based on how it came out? And most of the time, if it's the things we knew and we anticipated, and they came out the way we anticipated, hey, we already expected that. Why would we panic?
Yeah.
Let's get to our day. And you have
Yeah.
to do it a lot, especially when you're dealing with the people that are sitting there with you on the defendant's side, be they a representative or their care or their conduct is at issue. You've got to be a little more kinder and gentler to them in doing it. But every now and then, even they need tough love.
Yeah.
I told you, stand up and let's go through do it. I see trial as very, very organized, anticipated endeavor that the nuances turn on the fun time while you're doing what you already expected. In other words, getting a little bit better comment than you thought you were going to get, and going a little bit better and catching somebody making a mistake that you didn't think they were going to make. And those are the fun times.
Yeah. I think this is a great episode because we're not talking specific about trial tactics. We're talking about the process and how the process itself can be overwhelming and can really get to you. And you have to really focus on the process too, to know these things, to know that these things are coming. Talk to me about something I've seen over 22 years, but haven't seen a lot. And particularly since we're in this whole, aberrant, as you would call it, verdict phase,
Yeah.
these crazy verdicts, right? The high low. Um, wh- how come these aren't used more, John? Now, when I first got started in this industry, it was very, very common, very frequent that these were negotiated ahead of time. Now I just haven't seen them being used the way they were maybe 10 or 15 years ago. Is that what you're seeing? And what's going on with that? Because I see that as being just logically seeming being a pretty good tool to use to protect yourself. I just don't see it happening a lot. What's going on with that?
Yeah, things have fundamentally changed, and I agree with you. I think high-low is probably good for all the parties if you have a circumstance where that fits, and it has gone away. And I'll give you my opinion. Some people say I'm ultra partisan on this issue, and I am because I know I'm right. So going to that point, but basically, what we've seen is. With the plaintiff's attorneys now, the anticipation of the ability to get an aberration verdict and the potential of generational wealth is so high
Yeah.
that they find themselves unable to realistically cap the upside. And then, unfortunately, they also, even though they have this exaggerated view of where the case is going, they still want to get their whole cake on the low side. And so when you start negotiating with them, it becomes like it is in me. I think mediation is in trouble because plaintiffs lawyers start high, stay high, keep going high
Yeah.
because they're thinking and they're doing the same thing with high lows. And that's preventing the early discussions. The other problem is I personally believe the greed of chasing the dollar has made ethics situational for some people. And if you put a high low in place with many of these folks, you run a great risk that they're going to skate and violate every rule,
Wow.
knowing that you've got an appeal issue to it.
Yeah.
We now routinely, if clients ask me about high lows, I say, yeah, we ought to, depending on the person, obviously, we can look at doing that, but I think we ought to wait. We can go ahead and drop it out there, but we ought to not have the agreement until the evidence is closed because they will skirt the propriety if they know they've got a set field, high low with no appeal.
Yeah. Yeah. It's a very interesting concept, and you're right. Um, things have certainly changed. Um, Another challenge I'd love to get your feedback on, because again, I see this stuff every week and everybody handles it different. I've seen some things handled really, really well. I've seen some things handled terribly. There's a story I have in Indiana where a good friend and trial attorney, let's just say the judge was not on his side. and the judge did not like him, and almost every ruling went against the defense. And this particular defense attorney lost his cool, developed an attitude with the judge. Much of this in front of the jury, showed his frustration, and um, that's not where you want to be, obviously. How do you handle a judge that is clearly not on your side, and maybe not even personally like you, without completely backing down and just getting kicked around, but not going overboard to where, you're losing your cool, if not your professionalism?
Yeah, I think as a defense lawyer, and any lawyer, you got to first remember the jury likes the judge. I don't care how horrible the judge is, how terrible the judge is. Typically, they're going to see that robe as making them above everybody else, and so you got to take that into account. And you never want to go and undermine a judge in front of the jury on those issues. But what we do, and I do make objections. I'm probably one of the most frequent objector you'll see in any trial because I believe in preserving the record. We do it very professionally. We do it very, and I've had judges that have been very angry, and I just stay very calm and just go approach them. In fact, I had one judge in closing argument. I was doing a closing argument, and I went into an area, plaintiff's lawyer object, and moved for me to be sanctioned because the judge had said, you can't go into that area. And so, we took a break, and I talked to the judge, and I said, here's what I said. And she said, no, you didn't. You said this. And I said, no, let's get the transcript. Now the jury's out of the room, so I can be a little more confrontational.
Yeah.
We get the transcript, and it's exactly what I said. And the judge looks at me and says, it's not what you said, it's how you said it. And so, and so when we get back in, I just start very calmly in front of the jury, knowing that I'm in two different scenarios, two scenes. One scene the jury's out of, and I can be professional but maintain my record. And then inside in front of the jury, I'm going to be professional and coming across as I'm defending my client, but in a respectful way to the court. And I think you've just got to keep that. You believe it or not, many of these judges have plaintiff's background,
Yes.
and they are working on you to try to, and this again is my personal opinion, many of them are working on you to try to make your case worse in front of the jury because they lean, whether they admit it or not, to the plaintiff's lawyer. And so I'm going to sit there and do my best to be as respectful as I can while making my point. And I've had jurors come up to us after on these cases. Again, I never try to do it. It's that whole thing. If you got somebody that's done something bad, you don't point the finger at them. You just point your finger at the facts and let the jury point the finger at them. And that's what I do with the judge. By being respectful, then the jury starts to see the judge as not being fair. And we've had jurors comment on that.
That's really amazing. And related to that, something interesting you just brought up. Again, this comes up every week. Explain to me where I think I know where it's come from. I know there's zero scientific. I mean, I studied jury decision making. There's zero scientific proof of this. There is this deep reluctance by many defense counsel to object in trial under the assumption of, well, if I object, the jury's going to think I'm scared or I'm fearful or we're losing. It looks bad to object. I know for a fact, John, that is absolutely 100% not true. Yet there's this pervasive thought pattern, and we're talking across all four time zones of defense attorneys like, I don't want to object during the opening statement. I don't want to look bad. When there's clearly objectionable issues, you just need to get over that, right? I mean, I think it's very important to object.
Out of almost 200 trials, there's probably only one or two I didn't object during an opening statement of the plaintiff. I think there's several different, it's not an easy answer because there's several different things. One is competency level. I think many defense lawyers don't know how or the law quick enough to be able to object, and they're not quick enough to go up because you don't have time to think. If you're when it comes, you've got to have it already in your mind. You got to stand up and be able to go through it. I think too that some of them fear, just like some lawyers won't talk about damages in voir dire because they say, hey, the jury may think I mean damages. Well, if I can't communicate the jury enough to know that I've got to talk about an issue and it's still not something they ought to decide, then I've got problems. And that's what I do in voir dire. I talk to them, hey, objections are going to come. Wouldn't you want a lawyer? And I asked the jury pool, if you had a lawyer and the other side was doing something that that lawyer felt was a violation of the law or not proper under the law, wouldn't you want your lawyer to object? And would you hold it against them? And I get all the jury to agree that we're going to object, and they know it. And in fact, you can't make what I call stupid, repetitive, unsubstantiated objections. I would think if you went back and looked at my objections, and I object a lot, I bet you I get sustained 80, 85% of the time.
That's impressive.
And so
those are Caitlin Clark numbers, John.
Yeah.
Those are Caitlin Clark numbers.
but if you see, being objecting on things, if I'm in one of those areas where I know the judge is going to rule, then I make a joke out of it. Judge, I got to object again. And, and the jury looks and, oh, okay, and go through with those issues. So I think you've got to play to your audience, but whatever you do, you have to project the record, because let me tell you, all those lawyers that are afraid to object or concerned about what the jury is, if you get that bad verdict, you don't want to be in the room sitting at the round table with the people that ultimately are responsible asking you, why didn't you preserve the error in that issue? You don't want to be in that position.
Yeah. Yeah. This is great stuff, John. Thank you so much. I was in I was not in your neck of the woods, a little bit more southwest. I was in Natchez, Mississippi. Ever been over in there, right on the Mississippi River, where the Louisiana and Mississippi logging associations had me come and do a 1.5-day seminar. Check out this hat I got, a little Louisiana loggers hat.
Oh man, I'm liking it.
I got that bad boy. And they have all these big trucks carrying around all this, timber and stuff. So they, have a lot of transportation litigation. And halfway through this seminar, several of the attendees came up to thank me, and I was showing them some examples of crazy verdicts and stuff like that, and kind of breaking them down. And they said, listen, like, we really appreciate this information. They're very, and by the way, the most red-blooded Americans I've ever met in the logging industry. Geez. And trucking's the same. I mean, just great, great, great people. But they're like, you're talking about verdicts that are 45, 55, $100 million verdicts. They're like, if my company gets hit for a $1 million verdict, like, that's nuclear to me.
Yeah.
And that's what the people in this room are. Can you talk a little bit about how, the word nuclear and all this crazy stuff, and we see the articles on LinkedIn. Have we misread this? Because there's a lot of companies out there where a much smaller verdict would be devastating to them. And we're focused on all these, crazy, crazy verdicts. But I think isn't the term crazy relative to the industry you're in and the company that you actually have? Because maybe a $2 to $3 million verdict may put you out of business.
Absolutely. And I think you've got to be cognizant of those things in looking at it. The idea of these cases and being able to defend these cases really focuses on understanding the whole picture. And with a company that, $1 million is the company. And you've got to be prepared and work just as hard on that. People like the glamour. I hate mediators who come in and say, well, I've settled this $10 million case, and I settled. All of a sudden, their self-worth becomes in how much money was involved in the cases with it. And to me, the self-worth still ought to be focused even on those, lesser exposure cases, but have equally devastating consequences. So I think you hit it right on the head.
Yeah.
To the minute you start, people, well, I want to be a catastrophic lawyer. I just want to be a lawyer defending people. And if you do that, it shouldn't matter those issues, because it's just as important regardless of the dollar amount.
Yeah, because I mean, if I'm consulting on a $5 million case or a $50 million case, I do the exact same thing. Yeah. There's no change to my methodology, and I understand the differences there. And the $5 million case deserves just as much advocacy and effort from me and defense counsel as the $50 million case. And I think there's a lot of those cases out there. There's a ton of those cases out there. And I know that the big ones get all the media coverage and they get on all the LinkedIn articles. but you don't hear too many LinkedIn articles like, yeah, plaintiff hits on a $2.25 million verdict. Yay. You don't see those articles.
Yeah, yeah,
That could be a devastating verdict to a defendant, depending on what industry they're in.
absolutely. Yeah,
Yeah.
absolutely.
Okay, so how do you deal? I know you've been through this before. How do you deal with the defendant that's just lost their mind emotionally, and how to handle them? They're coming to trial every day with you. They're sitting at counsel's table with you, and they're terrified, John. They're
Yeah.
nervous. They're scared. Maybe it is a bet the company case, and they're trying to emotionally hold it together. Um, and oftentimes they fail at this. And a lot of my work is working with these people to prepare them for the emotional struggles, the ups and downs of the trial, to not let that show in their body language, their demeanor. It's really, really emotional, for a defendant, a named defendant, particularly one that's coming to trial every day with you. You have all these things to deal with, and for lack of a better term, you have to babysit the client as well and keep their head straight. So you're worried about getting your team coordinated, keeping your team's head straight, keeping your head straight, and then on top of all that, you got to keep the client's head straight.
Yeah.
How do you approach that topic?
It's Private Ryan. You've seen that
Yeah,
movie.
yeah, yes,
It varies from person to person and moment to moment. Sometimes you just got to slap them in the face and say, pick up your gun and go forward. And you got to be tough love in terms of that. Sometimes it's counseling. You're sitting around the fire, listening to them and hearing their word and reassuring them on going back. And a lot of it is the early preparation. I mean, they need to know. It amazes me the people that send their clients into trial without ever explaining to them you're going to have these up days and down days.
yeah,
You
yeah,
got to go ahead and
yeah,
explain all this in advance and let them know, hey, when we get here this day, let me tell you, you're going to feel like shit. Well,
yeah,
excuse me, you're going to feel
exactly,
terrible. But
exactly.
but we're going to come back, and here's how we're going to come back, and here's our experts. You give them more knowledge and discussion, and at some point, you just got to tell them, listen, here's where it is. You just got to keep walking with me, and keep trusting me, and then reaffirm it with them every day. I do find, and this will be a point. If you've got a defendant, a defendant with a group of people involved, and you have to pick, and several of them are witnesses, and you have to pick one of them to sit with the table with you. Most people will say, "Well, I want to go get my best looking, straightforward, best prepared witness to sit with me. I want to go get the worst witness. I want them to sit with me, the one that looks the worst, the one that testified the worst in deposition, the one that was it, because." Two things are going to happen. One, I'm going to normalize them in front of the jury over that period of time and ensure them. But number two, they're going to become better having seen the process. When you bring a witness in who hadn't been sitting there, it's like jumping on a train at 60 miles an
It
hour.
is
If I can get them in at the station and they're riding along with me, they
interesting.
know to expect the train's going to rattle. They're not
Yeah.
concerned and they become better witnesses. So I think it's all that preparation and just being direct and, treat them with respect, but also you're an authoritative figure. If you're the defense lawyer, you'd better gain control
Yeah.
and come in there and just exercise that control using all of those tools that Tom Hanks did so well in Private Ryan.
Yeah, great stuff. Now, back to LinkedIn, which I think is mostly good. I think sometimes it turns into Facebook some days, particularly this week. But I've seen a lot, and listen, plaintiff attorneys, they follow me. I follow some plaintiff attorneys. Hey, that's fine. A lot of plaintiff attorneys listen to this podcast. So, hello, plaintiff attorneys. I'm fine with that. I've had several reach out and tell me, "Hey, I love your podcast." That's fine. And I listen to theirs. They have a lot of podcasts,
Oh,
and
yeah.
and I think that they're well. I think that they're well done. Um, but yeah, I'm on LinkedIn, and something I've noticed, particularly in the last like 6 to 9 months, is and listen, everybody gets on there, whether it's plaintiff or defense, and they advertise their victories. And I think that's fine. I have no particular problem with that. If you win a case and you want to say, hey, I won this case in this venue, here's what it was about. That's transformed into taking a photo of the verdict form that's been filled out by the jury and putting that up. And now it's getting to the point, and this is the phrase I'm saying over and over and over and over again. I really want your feedback on this. Is the plaintiff attorney will say, not only did we win, but we won on a zero offer case. And they make this point of they offered us nothing. And so we
Mhm.
stuck it to them. A, is that true? And B, I see this like a lot, like the frequency of this zero offer, no offer victory that they brag about. If that's the case, like why in the world would that be happening? Like what's going on with that? You've seen these. I mean,
I've seen those posts. I don't know the story, the backstory on those. I'll tell you, these days, it's rare for any case to try that there has not been some
some
offer
offer, right? I
in those
mean,
cases. And those cases where there is zero offer very well could be a circumstance. Let's take the medical malpractice world. A doctor has a consent clause under the policy, and if they don't agree to make an offer, you can't make an offer.
mhm.
So maybe those cases were one of those, and unfortunately, the result didn't turn probably the way that the defense or the doctor anticipated. I think it's highly unlikely in a transportation case, a construction case, a products liability case, and in most auto cases, that you're ever going to see a case that went forward without an offer. But and people say this stuff. First of all, I think they're skirting when they talk about what was offered, most of that's confidential and privileged
Yeah,
anyway.
yeah,
But they still go ahead and do it. Nobody holds them accountable for doing that. My whole thought on the LinkedIn world, and I directly try to limit my stuff to the defense side. I know other people can get access, but I don't. Just personally, I don't friend. I don't. Uh, I block plaintiffs' lawyers who want to comment to me. I don't give a crap. If they want to pick up the phone and call me, come call me, but I'm going to
yeah.
block you if you come in and try to make your world my world. But I think the whole thing about LinkedIn is it is a good way to have communications across the system to inspire thought on issues. The advertising side of it, I think, is especially from the plaintiff's point of view, a little out of hand and a little. And you saw the example of the
Yeah,
defense lawyer in California. I don't know the details, so I'm not going to go into any details, but basically posted that we won this case and we shouldn't have, and ended up
yeah.
losing the verdict
Oh
because of
yeah,
that. I mean, what an idiot,
yeah.
and
I saw
whoever
that.
that was, and however it was. That ought not be the purpose. The purpose is to talk about, I think, sending out ideas of strategy, attitude, and others that people may be able to add or expand on and provide benefits so that we have a dialogue together. I wish there was a way to segregate so you could have comments on just within the industry itself. But the truth is, there's no tool out there. The plaintiffs' lawyers have it internally with their American Lawyers for Justice or
Yeah.
former trial lawyers, whatever they are nowadays. They have an intranet and they can do that. The defense really doesn't have that on that side, and LinkedIn has become important from it. I'm like you. I don't like to see the recipes and
Yeah.
my kids just did this or that. That's really
Here's my
Facebook.
dog.
Yeah, here's my dog. I don't really care. You have your dog in your office with you. Just do what you want to do. But I think sharing those ideas, LinkedIn is one of the few places from the defense side that we can get a broad audience to do that in. And so even though it has its limitations, I think that's the better use of it. And what one reason you do see the defense verdict is being published is in the general media and other areas. The only thing they don't really care if there's been a defense verdict. They
No.
care if there's a big verdict. And there's this thought and movement that we ought to publicize more defense verdicts so that people will know that they're out there. I'm kind of ambivalent on that. I don't know that really makes a difference from plaintiff's lawyers' point of view, if that's what you're trying to get to, and I don't think it works. But it's one of those things. It doesn't hurt to give people positive reinforcement
Yeah.
that you can go try cases. There's still people that are afraid to try cases. When those cases we try on the defense side, depending on the industry and the thing, you're winning 80 to 90% of them. Why the heck aren't we trying? We ought to
Yeah.
only win in about 30% or 50% because we're trying some borderline ones to go through, and we're not doing that now.
Yeah. Got a couple more minutes with you to wrap up. You've been trying cases a long time, John. You're very plugged in on the defense side. For particularly the last 5 years, I mean, I cannot tell you how many times, I mean, countless times that I hear the defense has to collaborate more. The defense has to share more information with each other. They have to be more coordinated, like the plaintiffs bar. Hey, hats off to the plaintiffs bar for being able to do that on their side. And it's been well known the defense hasn't done that. What's the state of the union on that front? I've seen some improvements. I still think it's woefully behind.
It's woefully behind, and unfortunately, it's designed in a way that it's not ever going to catch up in that level.
I hate to say, but I think that you're correct.
No, number one, the plaintiffs' lawyers have a financial interest in cooperating in terms of helping each other. The defense lawyers don't. The clients really want sponsor support. The defense lawyers spending time together, doing those things like the plaintiffs' lawyers are able to do from the ridiculous, contingency fees that they get,
Yeah.
and going through that. So I don't think structurally it's designed in a way. There's more efforts on that. We're working through American Legal Connections. Some other groups are doing things. There's structurally ways to do that. What I'm about to tell you is, I'll probably regret this, but
No, that's okay.
we everybody isn't Caitlin Clark.
Yeah.
And the thought that you can go take the defense lawyer and tell them, here's the techniques, and now you go do it, is like Caitlin Clark coming to, the nerd in the class and coming in and saying, hey, here's how I shoot threes. Now
Yeah.
you go do it.
Yeah, exactly.
There are, sooner or later, we're going to have to worry less about ego and more about getting the best team in place on that issue and developing people with such a level of experience that they do it. And the general thought that that's going to be across the board is a loser, and it's going to continue to be a loser.
Yeah. I've seen effort, but okay, since you think you're going to get in trouble, now I'm going to get in trouble. I've pretty much stopped. I've turned down speaking offers now from several. I'm not gonna say the names. They're the very popular defense attorney groups,
Yeah,
right?
yeah.
Which I have spoken at all of them multiple times. I've published with them. Um, I find, and I've heard that I've had defense attorneys very, very quietly call me and say, it's a waste of time and waste of money. These conferences are a waste of time and waste of money. It's just all one big cocktail hour. That's all anybody cares about. The speakers suck. It's regurgitated information, and we're not accomplish anything at these conferences. While the plaintiffs having their conferences and they're working like they are helping each other, they're teaching each other. We have shitty speakers, but boy, we have a really, really good happy hour and those events that we do afterwards. And I've had several. I mean, we're talking several defense attorneys quietly contact me and say, waste of time, waste of money. We're not accomplishing anything. And I tend to agree. And I've now just kind of avoided those conferences because I don't think it really does. Perhaps it's a marketing opportunity. I think everybody knows who I am at this point, but I just haven't. I'm just not sure if that's really if those events are really doing anything particularly positive for attorney growth or education or true training. I'd love your thoughts. And if you disagree, that's fine.
No, unfortunately, I agree on most of the components of it. I think, um, and I'll try to be careful here.
Yeah.
These events where you go to, a fancy city and you've got a ball game in the
Yep.
afternoon, a big expensive dinner. And by the way, the people that are paying for it are the law firms.
Yes.
But the clients are invited,
Yes.
and they usually get bought in on a discount or for free. And all it is a marketing event.
Hmm.
And you go get the folks that are doing it, really interesting. You go stop at the speaker and go look at a speaker who's talking on defending damages, and go look at how many trials they had in the last 6 years.
Yeah.
And if they've had no trials, it really
What?
raises some questions.
Yeah.
Um, and I think unfortunately it's many of those, and we pulled out of a couple of organizations because we were not concerned. We didn't think it was the right focus.
Sure.
That's what we're trying to do with ALC, is to make it very focused on being a think tank of an exchange of ideas
Yeah.
for those people who can make a difference, and work through that. I do think we ought to continue to do it. And let me give you an example. We started talking about defending damages in 1996, 7, 8. For years, people would say that's stupid. Nobody's going to put up damages in these tort cases. You're losing your liability, which is not true. You increase your chance of getting a defense verdict when you do that. When you're going through, and now there's such a because of aberration verdicts, there's such a movement. People will now parrot to you that we defend damages because they think that's what they're supposed to say. But then when you go look, they don't really.
Yeah.
And until the defense organizations come together in a way that, as you said, that's really nuts and bolts to make the change and the idea, and it gets adopted, understanding the talent issues that we've talked about earlier. I'm not sure it's a great investment. It's certainly not for me personally. I mean, I'll go talk to somebody, but to go sit through, people that I know don't do it, tell me how to do it. I don't tend to do that.
Yeah, I get a lot of like, are you going to this city to this conference? I'd love to hook up. And I'm like, no,
Yeah.
nah, it's not. It's not where I want to be. Okay, final question. I actually I think this is the most important question actually of the day. That again, like you hear very quiet talking about this. I think this is a massive issue on the defense side. Is the development of the young defense attorney. Um, I see big trouble in the next 7 to 10 years when experienced guys like you say, you know what, I'd rather, I'm ready to go fishing every day or go to my other house or, I want to spend time with my grandkids. I don't need this shit anymore. And you have the people, behind you coming up. I've seen a lot of um, jumping around of young attorneys from the firm and not sticking it through. I do think just based on this is just my observations. I think the plaintiffs bar has done a much better job in training their younger attorneys, and I've seen that in courtrooms. I've seen that in depositions. Um, what advice or guidance to young attorneys would you give? Because I think their development is really important. Many 30 and 40 something attorneys listen to this podcast, and they do for a reason. Is because I've had young attorneys call me and say, I learned more from your podcast than I do at DRI
Yeah.
because of the guests that you have and the thing. Like that's why I listen to your podcast. I think it's a really important topic. How do you handle that at your law firm? But just maybe generally speaking too, if you're that 30 something, early 40 attorney and you're wanting to, either your young partner or you want to make partner and you want to get to the John Hall level, what do they need to be doing?
Yeah, I'm glad you asked this question. It's something I'm really focused on these
Yeah.
days, trying to go through. I do think there has been a change in the people that go to law school. I went to law school because I knew I wanted to be a lawyer and I wanted to stand up in a courtroom. And back then I was stupid enough to think, maybe that'd be politics too. I quickly learned that wasn't the way to go. And so, but I went to law school with a purpose. And I think many people now go to law school because they don't know what else they want to do. And, there's either funding for it or parents to pay for it. And then they get out of law school and, they find out that what we do, if you want to be on the litigation side, is extremely hard work and requires a lot of commitment. And there's other avenues outside of the law or other avenues that inside the law doing, routine things that are easier in that perspective. So I think you have less of a candidate field than you used to have of those people that want to be there. So I put that as a caveat at the start. Some of those people we can talk to all day, blue in the face, and we're never going to, they're not going to be trial lawyers. But I'm a strong believer. I like millennial jurors. I like Generation X jurors because I think I can talk to them and give them facts and reason that, or at least what they look at as a fact and reason, and show it to them in a way that makes them engage. And I think the same thing with young lawyers. What we talk about is we're a different, like, we want to hire to retire. If you, there is now a group of lawyers that come in and every 2 years they make a change because another firm will throw a $10,000 or $20,000 at them. It's interesting to watch the long-term track on those
Yeah.
kind of places and firms. And you don't learn a whole lot making those transitions. I look for a lawyer who wants to be entrepreneurial. Our firm's pretty transparent. We want everybody to come in and be a partner. We want to develop business. We share business. And so I try to look for that person that's entrepreneurial and wants to build a long-term career. And then as part of that, we put together something we call HBS University. We do training sessions and mentoring sessions. We need to get better at it. Everybody always needs to be better at it because you're busy with all the stuff that we do as lawyers. But we continually try to hone in and try to give opportunity to learn and to do those. And we encourage teamwork, cross marketing, so that you feel part of a group. And I think people stay, but we've had people turn down 50 grand more because they knew in the long term, and that
Yeah.
firm 50 grand more in 6 years, they were going to get kicked out because,
Yeah.
nobody's going to make partner at those firms.
Yeah.
But in our firm, they know they'll make partner. And not only will they make partner, we'll train them, we'll introduce them to clients, try to get clients to send them business. We'll try to work with them to develop their career on the defense side. And so if you find somebody that wants to be a trial lawyer, has an entrepreneurial fee, then you foster that through education and opportunity. I do think, within that, part of the funnel of people that, are going to go out is those that really don't want the stress, as we've been talking about, of trial work. And there's nothing wrong with that. You just hope they recognize it soon enough before they get in a situation that becomes difficult for them. And then the other thing I think we have to train our young lawyers to do in the stressful world we're in is the facts of the case are not you. You didn't do the surgery, you
Yeah.
didn't leave that in, and you've got to learn to be able to separate it from who you are personally. You're there to take care of other people's issues, and it's not you personally who did that. It's amazing to me the young lawyers I see who become emotionally distraught because the plaintiff's lawyer is all over the client on what their conduct was, and the lawyer now emphasizes and takes on their guilt like they're guilty because they're defending that client. And so we work real hard to try to make sure, those folks who can't separate that out, we give them other opportunities, but those folks who can, we look at ways to develop that and make it better for them. And develop that long-term opportunity of what you want to do. This gets me in trouble, Bill, and my partners and others tell me not to say it. I tell folks, if this is not absolutely the best place for you, this firm,
Yeah.
go somewhere else.
Yeah.
And people think, oh, you're being an ass. No, what I'm being is I'm going to bend over backwards. I'm going to do
Yeah.
everything to give you the training, to pay you everything we can under the circumstances, to give you the opportunity to build your practice, to get you clients, to have you a long-term career. And if I'm not good enough at that, then you deserve somebody who can be good enough. But I'm going to do everything I can to help you. And it's creating that R or mentality, culture, whatever you want to call it, that the firm is invested in them and wants to give them the opportunity, I think is the best way. The trial lawyer side of it, real quickly, and I know I'm going along.
That's
On
okay.
the trial lawyer side of it, companies have to, we've got a couple of companies, they don't want any lawyer less than 5 years working on their cases.
Yeah.
What idiots. How do they
Yeah.
think the lawyer got to be 5 years?
Yeah.
And it's ridiculous. What we have to do is companies have to understand that if they don't invest in allowing young lawyers to work on these cases, and by the way, if they don't start trying those cases that we have no liability on, but you could settle for 50 grand, but it's going to cost you 50 grand to try it. If you don't start trying those cases and letting the young lawyers do it, you won't have trial lawyers in 5 to 6 years from now. You'll have trial lawyers, but it's going to be the ones who won't object, who sit back in a panic and telling you got to pay more money. And if that's what you want, you're on the right track. But otherwise, you've got to change it. We got to quit trying 3% of our cases, and we got to try 15 to 20% of our cases. We got to quit settling the no liability cases and try every damn one of them. We have to change our mentality. The industry does.
Yes.
The law firms have to first, but then the industry does.
Totally agree. John, thanks so much. Stick around so we can chat offline. Excellent conversation. All wonderful thoughts. This was fantastic. Thank you, John, so much for coming on the show. Thank you to our audience for listening. This has been another edition of the Litigation Psychology Podcast. We will see you next time.